Court does call the case of Haverhill on Clark versus Jeffrey Thompson.
Good morning, Your Honor. J. Begg, P. 36820 on behalf of plaintiff.
Good morning, Judge Simpson. It's Jeff Thompson.
All right, you can take.
Oh, sorry.
All right,
Oh, sorry. Oh,
Well, we had a hearing maybe a week or so ago, and you instructed Mr. Thompson to file an answer by the 26th of last month.
I think I gave him to. Well, hold on. Yes, I did. Right, you're right.
He said he filed it. I checked with the clerk here, and it may not have been received by the court. He said that he mailed a copy to plaintiff's counsel. In any event, I had him email me a copy, maybe about half. So I'm in a copy of his.
unfortunately, Judge Simpson, the court doesn't even have the representing attorney's email on file. There's no website online that we can get the email from. The telephone number that we call with my CMH case managers is just a generic telephone number with no idea whether or not it's a law firm or not. The information was sent electronically. We called the court to make sure that it was.
Well, hold it. You received paperwork at the beginning of this case.
What do you mean?
Well, you received the complaint, right?
Yes.
And if I'm not mistaken, counsel, the complaint has your. The complaint has all of counsel's information.
Yeah, it's not. The information was sent to his office. The girls, now I just checked with the clerk's office. It was received on Wednesday. They said that they're going to walk down, down a copy today.
I'm not going to make an issue about the answer. I mean, he
Yeah, it just came in this morning. Do you have a copy?
Yes, exactly.
You do. Do you have a copy?
I do have. Yeah,
Okay.
I had a meeting.
All right. Let me just see this because I have not.
Right. Settlement is not likely. I think this is going to go to trial, so I think we're going to set some dates.
All right, what primarily is the issue in this case, Mr. From your standpoint?
I had psychological challenges, which I just recently went inpatient for.
Pardon?
Know about some mental health issues, and just recently been taken care of. We started a whole new medical regimen with meds, but we're slowly going to tweak them over time. I've got 2 different psychiatrists that are following me at U of M. I'm now involved with case management and with CMH, which has all been really helpful. It's just there was a lot going on at the time. My dad just died a couple days before the event, and my mom's in a nursing home right now. So I mean, there's a lot, and I know that that's ancillary to this case, but it's affected me in a lot of different ways that I never thought possible. It's really brought up a lot of the behavioral health, mental health issues. So I've got a grasp of them. I'm doing well. I've never bothered anybody at the apartment complex. I love my neighbors. They love me. And I thought I had a great relationship with the staff there because they're always really nice to me. I wouldn't have a reason to think otherwise. I mean, I don't want to lose my home, and I'm feeling a lot better now. It's really hard, So even standing here right now, I get nervous when I'm in here. I'm nervous in front of you, and this guy makes me nervous. It's just a long time ago. I couldn't tell you. I just run the opposite direction.
And so in terms of the specific behavior, is your client open to any type of probationary agreement?
I was thinking about that. I don't believe so. They're pretty adamant about terminating the the lease. There were two incidents, as noted in the notice to quit, which is part of the file. I won't get into the details here, but it's
I was
in-
sick.
in-
Your Honor, I'm sorry.
Yeah.
I gladly admit where I'm wrong. I know,
Pardon?
I know where I'm wrong. I didn't know what I was doing at the time, and with the person I was dating, and I'm sick. I'm doing what I need to do now to get the help that I need, and it's really intimidating to be up here right now. So, and it seems like it's every couple of weeks that I have to come back, and I know it's a process, and I know that
Right, but I guess what I'm,
bless you.
do you have, I mean, have you tried to provide or provided any type of medical documentation, even for plaintiff's consideration in this?
Yeah, I tried to, and we tried because it said in that first notice that they were trying to talk to me within the first 10 days. And Latasha, the property manager, was really nice. She tried to work with me to get that, but I guess it was her manager that said no, that she didn't want to talk. Within 10 days of receiving their paperwork, she said that they had to talk to me, or they could talk to me.
Right, I get that reading. I'm
sorry.
what I'm indicating is, and if what you're telling me is not what you're telling me, then tell me that, okay?
Okay.
But as I'm understanding it, you are having mental health episodes that led to these incidents.
Yes.
Okay. I'll just ask you this. What do you have that would tell me that's the case?
They've diagnosed me with bipolar, generalized anxiety disorder, and clinical depression. I also have an autoimmune disease.
Okay, but I realize it doesn't work specifically this way, but on the dates of these particular incidents, what do you have that would tell me or anyone else that it was some type of episode, manic or other?
I'd have to get it from the psychiatrist at Michigan. I'm sure they can give you documentation of it, or let you know what happened. They can give you the documents.
Then maybe I'll ask another question.
Sorry,
No, it's okay. After each of these incidents, did you go to a healthcare professional?
yes, yeah, I was seeing a therapist and the
Yeah,
psychiatrist.
but how soon, like the incident occurs, how soon did you go?
Probably just the days afterward, if it was even a day. They have the information.
And you went because
I was scared. I didn't know what was happening to me.
okay. And that occurred on both of these incidents.
I believe so. Yeah. They did.
Okay. And without getting too much into what may have been told to you, your healthcare treatment providers, they said that you were suffering from something at that point. Is that what you're telling me?
Yes.
Okay. That information, have you provided that to plaintiff at all?
No, not yet, because I didn't think we could. I'm sorry.
Pardon?
After they said they didn't want to talk to me, I didn't think they needed it, but I can give them a copy. I'm sure the doctor can even call them if they wanted to as well.
Well, that gets into a whole other complicated thing, but
Sorry.
all right. So let me ask you this. If you don't provide that, what would you be at? What are you asking the court to do?
I don't want to lose my home. I've done everything that I can over the last several years to acquire, and I came from a really bad place at Arbor One prior to that time. And
Were you
just trying to deal.
residing How long ago were you residing at Arbor One?
Last year, for a couple years.
And you moved from Arbor One because,
Was condemned by the state of Michigan.
yeah, okay.
I'm sorry.
So who relocated you?
It was the Section 8 vouchers.
Got it.
Yeah, maybe we set up for another settlement conference, or at least give him time to provide, counsel the, medical documentation that he's.
They can do that.
Yeah, and so remind me, how long have you been in this unit?
Since June, beginning of June. Latasha tried to get me in as quickly as she could. They were really
The
helpful.
beginning of June of this year.
Yeah.
And then this, okay. And you moved right from Arbor One into,
Yeah, because my building was really bad there.
what was your address there?
723.
Green?
Yeah.
Okay.
I just feel
It's amazing. I know.
And
Well,
next.
pardon?
I just one thing after the next. I'm sorry. I don't want to sound.
No, it's counsel. I don't know if you know anything about that whole situation.
I don't, but I think I'm getting a flavor of it, now.
Yeah, and so I'll just say it this way. He would have been one of the individuals, in particular with the address that he's given me, that was for probably an extensive period of time sitting in a condemned building.
Yeah, I had mold inside my system too. I got really sick while I was there. The doctors have that on file.
Okay. And so there was just to give a sort of a sketch of it, there were initially cases that were filed before me. They were removed to the circuit court. The county prosecutor filed a civil claim along with the city of Ypsilanti. Thankfully, in a lot of ways, it went away from me and it was up in circuit court. There was in a federal court, and all of that is pending.
We appreciate what you did, though.
Pardon?
We really appreciate what you did. You really helped a lot of people, including myself.
Well, thank you for that, sir. I do appreciate that. So here's what I'm going to do. I'm going to set a new date, but here's what I'm going to want you to do. You got your worker's not here today, right?
No, I got to go see him after it. There's a 2-hour therapy session after this at 12:30.
Okay. So what you're going to need to do is provide medical documentation to plaintiff's counsel.
Okay.
I'm also going to want a copy to the court, but
Okay.
here's what I'm going to tell you. You tell them when they bring it to the court to put it in a sealed envelope
Okay.
and address directly to me.
Okay.
Okay, because what I don't want is, I don't want, to any extent that we can avoid it, I don't want all of your medical in a court file.
Okay.
You follow me?
Yeah, I do.
All right. So how soon do you think you can get that done?
If it were on my time, so I'll get it to you right now, but I don't know what theirs is. Maybe.
Okay.
Is that okay?
Just slow down a bit.
Okay.
Just, give you time to get it so that plaintiff's counsel can have time to consider it and the court can look at it and just try to figure it out. When's my next day?
Your next date.
Thank you. Thank you.
Okay, that's not going to be enough time. What's
You gotta give him more time. Yeah, more time than that.
okay? Here's what I'm going to do. I'm going to go to January 6th. I'm not going to take the December date. Okay. But so I'm going to adjourn the final settlement conference January 6th, 2026 at 9. Okay, and how soon, so what I'm gonna do is I'm going to then require that you get it to the court, as I've said, how to do that, and also the plaintiff's counsel. What's today, the 2nd?
Also, he should mail it to plaintiff's counsel. It shouldn't be emailed just because of the nature of the information.
Hard copy though.
Huh?
Oh, he maybe with the holiday, we sent a hard copy to both.
Yeah, again, I'm gonna circle the,
Send, what counsel's telling you is don't send it through email.
Oh,
Okay.
Sorry.
Get a hard copy, mail it out to plaintiff's counsel at the address that's on, that they have, okay? And I want you to provide that, I'm just gonna indicate by the 23rd
Okay.
of December, but if you can do it earlier and try to get it to them,
Yeah, I'll tell them
Okay.
today. Thank you.
okay, and try to get them as soon as they can mail it out so that council can go
I
through it.
understand.
Working, okay?
Okay. Thank
All
you,
right.
Thompson.
Not a problem, sir. All right.
Help with
thank you,
number one.
Judge.
Thank you, counsel. What do you say?
Thank you for all your help with number one.
You're welcome. Harbor Woods versus Adriana Owen. You know, we don't see her like forever. She was just his head on the, in a, like the Zoom screen. And now this is like the 3rd time, not that I'm counting. Hello, go ahead.
Good morning, Your Honor. Casey Matson, P 87729 on behalf of plaintiff.
All right. Your name? All right, where are we on this case?
Your Honor, we did have a chance to discuss, we did come to an agreement. Not sure if you would like it in the form of a conditional dismissal or a separate order and dismissal. I do have a conditional dismissal prepared here for you.
Okay, well, we can maybe do it that way. What do we have?
Your Honor, we did look over the numbers and agree to an amount. The rent to retain is $3,632.63. Court costs of $186 for a total of $3,818.63. Your Honor, there is escrow in the amount of $3,906.21 held with the court. We did agree that that should be released to plaintiff and applied towards that amount, which would again leave her with a credit on her account for January as well.
And so then she would satisfy the conditional order dismissal.
Yes.
Yes.
You're just smiling. You didn't, words didn't even come out of your mouth. Is that agreeable to you?
Yes.
All right. Okay, I'll do it this way just to make sure, and we do have, and I would verify that we do have the escrow amount that's listed here in the court file, so we'll send that over. Do you have any questions regarding this conditional order dismissal?
No, sir.
All right. None?
None. I already asked the questions that I had.
Well, she represents the other side. So I know she was probably really nice to you and answered all of your
She
questions.
cleared it up. It was the paper that she presented to me with the numbers that they came up with.
Okay,
So she cleared it up. So
okay,
I don't have
in
any
terms of the
questions at this
accounting.
moment.
Okay, so you're good with this?
I'm good. You won't see me no more.
Well, I don't, it's not that I don't want to see you. Not like this, all right? All right, you can come by and just say hello, but, all right, listen. I do have to advise you, since this is a conditional order dismissal, that you have 3 business days to think about this. If you
Okay.
believe that there's some legal reason, some right you didn't assert, some confusion on your part, you'd have to file a motion with the court within that time frame.
Okay.
Doesn't mean that I would grant it, but you'd have to do that.
All right.
All right. Okay. Whoops. I will mark this file conditionally dismissed. I've signed the order. And counsel, I don't know, Miss Dornbush sometimes was, how do I want to say this? She wanted to make sure her client got the check right away.
Mhm.
And so she asked me Yeah, okay, it's Dornbush. She demanded of me to have the check prepared in a couple of cases. Did you wish that done today? Because we can try to arrange that. And she took the check with her, but I don't know if you wanted.
Your Honor, I'd just prefer it be mailed to our
All right,
office.
we'll mail it out.
I can do a separate escrow, order releasing escrow if that's necessary.
It's not necessary.
Okay, thank
All
you,
right.
Your Honor.
Thank you guys for working it out. You take care. All right. And you know what? You just keep smiling. What?
Always do.
All right. What were you going to say? I'm sorry, I interrupted
That's
you.
what I always do.
All right. You have a great holiday.
You too.
All right.
Thank you, Your Honor.
Thank you. 2 out of 3 down. Now something tells me everything's going to go sideways. Court does call the case. I shouldn't say that. Jerome versus Cassidy. I have people on.
Yes.
Good morning, Your Honor. Gail, Rosen appearing.
Okay.
Your Honor, Abby Cooper appearing on behalf of plaintiff, the Drones.
Joe Lloyd, Your Honor, appearing on behalf of Mr. Cassidy.
Okay. And then Ms. Tope is here. Yes. All right.
I am appearing on behalf of Cambridge Family Holdings, plaintiff and counter defendant in this case.
All right. So I think probably the first thing that we may need to deal with is, Ms. Rosen, your motion to withdraw.
Thank you, Your Honor. I do want to make one correction. I noted in my motion that Mr. Lloyd is co-counsel for Ms. Cassidy. I learned after filing the motion that this is not correct. It was my assumption that Mr. Lloyd was representing both Eric and Paula Cassidy as he replaced Francine Ovar, who's been representing both Paula and Eric. She and I were co-counsels representing Miss Cassidy. I've since learned that Mr. Lloyd is only representing Eric Cassidy. But as I stated in my did you have a question, Your Honor?
Well, no, go ahead. Go ahead.
As I stated in the motion, as Miss Cassidy is not eligible for services from our office, student legal services, we're unable to represent her. She needs to both be currently enrolled at University of Michigan and current on her tuition. We routinely check with the registrar's office to determine eligibility for our services. And since, as I indicated in my motion, she has not paid the tuition, which includes fees for student legal services since fall of 2024, she is not eligible for our services. It's my understanding that Mr. Lloyd is going to be requesting an adjournment of today's hearing or an adjournment of time to file the answer, which would provide ample time for Ms. Cassidy to hire new counsel or seek representation from Mr. Lloyd, who is already representing Mr. Cassidy in this matter. As such, I don't believe that our withdrawal will have a material adverse effect on Ms. Cassidy or her interests.
Do you have anything to say regarding the
No,
motion?
Your Honor, plaintiffs do not oppose the request.
Mr. Lloyd.
I think what she said is true. I don't have a dog in this fight either. I do not represent Paula Cassidy, as I understand it. And I think she has filed a document with the court. If you've seen it, sort of laying out what she wants to do. But I don't speak.
Who, Ms. Cassidy?
This morning, she filed a 2-page response. I filed for her, and she can't be here. And she's
I got it. It came in. I have not. Oh,
You don't mind. She opposes, but she really is just asking for.
I got, thank you. Hang on. You've not seen this, Miss Rosen, I take it?
I received it this morning, Your Honor.
And maybe you can. She says she is enrolled as a graduate student.
Tuition has not been paid, Your Honor, which includes our fees. So a student has to be both enrolled in classes
And pay, got it. Okay. Okay. So she goes further on to say, are we really talking about $8.50? Or
no, the $8.50 is what our student legal services fees are. It's included in the tuition. So tuition has to be paid in order for students to be eligible for our services. It's part of the tuition.
Right. You wanted to say something, Mr. Cassidy.
Yes, Your Honor, just as you know, she can't be here, she's in class. I know she would disagree with what Ms. Rosen is saying. There's an engagement letter. It does not require tuition to be paid. The second part of it that Ms. Rosen does know is Paula has a payment plan with the registrar, in part because she's incurred for cancer treatment. Why Ms. Rosen hasn't told you that, I don't know. But she's been told by the person who runs the clinic that the actual fee at issue is $8.50. Paula has complied with the engagement letter 100%. She is currently enrolled and has a payment plan with the registrar that Ms. Rosen doesn't have access to, but she's told me that's the case. So really, this is somewhat unfortunate pretext, as I think Paula says. More than anything, she wasn't given notice that this was going to be heard today, and she would like some time. If there's some resolution that can be that SLS, great. Then if not, she'd like an opportunity to be here and explain her position.
Your Honor, if I may, the information that we received from the registrar's office. The only information that the registrar's office provided to us is that the tuition has not been paid. I don't have anything further from the registrar's office. Additionally,
okay. Would it be your understanding that if there's a payment plan that they've approved, that would suffice for the purposes of continued representation?
I don't believe that it would, as our fees have not been paid. I mean, the only information we get from the registrar's office is that the tuition has not been paid since the fall of 2024.
Okay, but I guess I'm a little bit confused, only because if a student was waiting on financial aid from get there, but they know that it's coming, I don't know that it would, and they're still attending classes, everybody's just waiting on the funds to get there. That may place them certainly in a circumstance where hold on one moment. Who was that? Oh, just tell her to walk in.
Okay. We're gonna go tell.
If she's got something.
No, she's gonna.
Okay.
Okay. Anyway. No one answer knocks at the door. Okay, so if it would seem, I guess somebody, given her objection, somebody would have to clarify for me that if she has a valid payment plan with them, why that does not then provide for her to have access to the services.
Usually, Your Honor,
go ahead.
In a situation where a student is waiting for financial aid, that's usually paid within a matter of weeks. This has been over a year or almost a year at this point that the fees have not been paid. The tuition and fees have not been paid. And I also think, Your Honor, at this point, not to switch gears, but that at this point, I believe that there's been, in addition to the tuition issue, there's been a breakdown in the attorney-client relationship. I have been advised that it's Miss Cassidy's opinion that I am incompetent and unethical. I don't think that that's the basis for a continued attorney-client relationship.
Well, I was going to get to that next, and I'll just say this, and I understand people can have their views of attorneys and everything, but I'll just say it, that's not you.
Thank you,
And
Your Honor.
that as I read those statements, that you were somehow unethical with her, or misrepresenting her, trying to provide a pretext, and then not only doing that to a client, I don't believe that at all, but further that you would take that and provide that same information, some false representation or some misrepresentation to this or any other court. That has never been the way that you practice. It is not you. And quite frankly, I don't believe it. So I'm just going to lay that out there.
Thank you.
I would then indicate, I think you're right, that I will grant the motion to withdraw, but not on the basis of the failure for the tuition to be paid. Because otherwise I'm going to get into a whole big whatever of, does a payment plan qualify? Does it not? Has the actual fee for the representation be paid? And I don't know that in the long run that's going to matter, because if I were to then deny the motion, Ms. Rosen and Ms. Cassidy I would then get another motion, quite frankly, asking that Ms. Rosen would be asking to withdraw because of a breakdown in the attorney-client relationship. And I would agree with that notion for the basis for withdrawal, particularly given the statements that have been made on this. And I'll just say one other thing. I've been involved in this case since its beginning, and I don't know the conversations that take place between attorneys and counsel, but I can tell you that, to the extent Ms. Cassidy can hear me on this, just understanding that Ms. Rosen has been a ferocious, and I don't mean that in a bad way, but a huge advocate for her and zealously representing her in every moment that she's appeared before me or when we've had our bench conferences. So I'm going to permit the withdrawal on the basis that the attorney-client relationship is broken down. That may be, quite frankly, to Ms. Cassidy's, certainly not to her benefit, because I think she had one of the best attorneys we have out there. So I don't know how much time she has indicated a certain schedule here, but I don't know how much time she's going to need to get an attorney to represent her in this matter. Mr. Cassidy, you have any idea how long?
A week to 2 weeks. We started working on it. However, this motion was given to us on a Tuesday, Thanksgiving. So.
All right. Before I do that, is anybody going to have an objection given the circumstances to an adjournment? I'll hear it, but I'm going to adjourn it anyway.
Your Honor, adjourning the motion regarding jurisdiction or adjourning?
I'm going to adjourn everything because I don't have somebody representing Miss Cassidy. I'm ready to hear argument certainly on that, but I don't know if Miss Cassidy is going to have a different position. So.
Okay.
And it may not matter. I get it.
I understand. Well, I guess the motion, just as a practical matter, the other motion before the court today is the motion for the court to obtain concurrent jurisdiction, order removed to circuit court. There was no objection filed by anybody. Is the court still inclined to adjourn that as well?
Yes.
Okay.
I understand why I may not, but it seemed, given Ms. Cassidy's objections, that she was much more preoccupied with the withdrawal counsel, so I don't know if that was addressed.
Okay.
Put it that way.
Then, Your Honor, I would request we have a specific time frame. It sounds like they were open to 1 to 2 weeks to obtain new counsel. And then, moreover, the court had previously requested or ordered that the defendants answer any amended pleadings as of yesterday.
Yes.
That did not occur. So we would further request that a new deadline be ordered by the court and that it be honored for answering the complaint and filing any counterclaims.
And that was from the Cassidys. That was
Correct.
right. Mr. Lloyd.
I'm perfectly comfortable with adjournment. I do need more time to properly address the claims that are made. And I was going to be making the same request the same relief for different reasons.
Got it. Okay. So I love scheduling things in December. I have the 2nd, 9th, 16th, and then January 6th. Quite frankly, I think the practical is going to be January 6th, because by the time counsel gets involved, that's going to give you enough time, Mr. Lloyd.
Yes.
By the time Ms. Cassidy gets counsel, they've got to figure out what's going on and get an answer. So I'm going to set this for the 6th. Answers by both Mr. and Mrs. Cassidy need, as well as any counterclaims, would need to be filed our last day before the holiday being open. Well, I'll give you 3 weeks to get that done. So by the 23rd
Thank you.
of December. Will that work?
Yes, thank you.
Yes.
All right. Is there anything else from anybody else? Ms. Rosen, did you file a proposed order with the court? I don't.
No, I will
No,
submit one though.
All right, please do that. And why don't we do this in that order that I've allowed to withdraw? If you could include those future dates and when the answers due, so that once
Sure.
that's served by Ms. Cassidy, she'll know. So if you could do that for.
Sure,
I'd
could you just
appreciate it.
remind me of the dates?
Yes, the new, I guess we're the 23rd of December. The defendants, counter plaintiffs in this case, are to answer the complaint and file their counterclaims by that day,
And then returning to court January 6th?
January 6th, 9
At what
a.m.
time? 9 a.m.?
9 a.m.
6th is a Tuesday.
It is.
Thank you.
And that's to hear the motions and for a study.
That's it. Yes, hear the motions, and I think I've got to hear the motion before I can decide what we're going to do. So,
Understood.
all
Thank you
right.
very much for your time, Your Honor.
Thank you. Thank you,
you.
folks.
Thank you.
Thank you.
Thank you, Your Honor.
Pardon? Thank you.